Okay. Yes, Onyendo Batagona court. So he has entered inside the court, and you can see that he's talking about they did not allow him to file the process yesterday. So but they're making arrangements now to go and file it this morning. So that is why you can see that he just entered. And the DSSS are trying to go and call court officials to enable him to file the process in court. So that is where we are here now. So everybody is there. Oh, here. Oh, here. You can see me in my position. Yes. We are here. Look at special counsel. Special counsel is in a with you one. If I want to log out, finish.
All right. So Nnamdi Kanu, the leader of the indigenous people of Biafra, has appeared in court today. Today is the 7th day of November 2025. Oh yes, in fact, I call today the D-Day because a lot of things is going to go down today. Let us see if Nnamdi Kanu will eventually open up defense or he will still insist that he has no case to answer in Nigerian court. Of course, Justice Omotosho has warned him to open up defense or face whatever judgment that comes before him. So let us see how it's going to go. Today is really going to be the day that we've been waiting for. Now, as you can hear one of his lawyer, Maxwell Opara, saying that some of the documents that Nnamdi Kanu is supposed to have gotten, gotten affidavit or printed since yesterday, DSS did not allow him to do that, not up to this morning. You can imagine the kind of country we are living in. So please, I want to beg you to stay put. All you need to do is to subscribe to this channel because I'm here live and direct to get to all the information of everything that is happening in that courtroom. All right? So all you need to do is just to subscribe, turn on your notification button so that anytime I upload a video, you'll get notified and know what is happening, because I tell you that a lot of things is happening in Nigeria. Now, I'm going to allow you to listen to this information because it is from this information you're going to watch now that will determine or you will know what we are expecting today. Okay, so please do well to listen to it. Then you drop your comment in the comment section. Do not forget, as I always say, pray for our leader. Pray for Nnamdi Kanu. Pray for the state of Biafra. Pray for prisoners of conscience, that God will continue to bless them, to guide them, to give our leader Nnamdi Kanu wisdom at this peculiar time to carry out this course. All right? So please listen to this.
When Omotosho ordered Nnamdi Kanu to proceed with his defense, Nnamdi Kanu replied the court saying, "My lord, there is no law backing my prosecution. If there be any law, please quote it." Then there was silence throughout the court. Nnamdi Kanu went on to say, "The Terrorism Act 2011 and 2013 as amended, which is being used to try me, has been repealed, therefore does not exist." Now, this was a statement Nnamdi Kanu said yesterday as regards the TPAA Act 2013. Exactly what happened. Nnamdi Kanu's address centered on jurisdictional foundation of the case. His submission was that the entire trial is void ab initio because it rests on a repealed law, namely the Terrorism Prevention Amendment Act 2013, TPAA 2013, which ceased to have legal existence following the Terrorism Prevention Act 2022, TPAA 2022. He argued that jurisdiction is the lifeblood of adjudication, not a procedural formality, citing the Supreme Court in Madukolu versus Nkemdele 1962, which held that a court is competent only when the case comes before it under a valid subsisting law. Now, what is this TPAA law all about? And why does Mazi Nnamdi Kanu keep quoting the law, telling the court that the law has been repealed and replaced, and in fact, that there is no law that supports his prosecution? And in fact, also, how does this argument aid Mazi Nnamdi Kanu's court victory and also lead to the striking out of the case? Follow me as I take you through this video. Whatever you're doing, I advise that you leave it and focus on this video because you do not want to miss a bit of it. Let's go. Now, what the law says about repeal in Nigeria. Let's go on from there. Under Nigerian law, when an act is repealed, it ceases to have legal rights. This principle comes from Section 6, subsection 1A of the Interpretation Act, caps 123, Laws of the Federation of Nigeria 2004, which states, and I quote, "The repeal of an enactment shall not revive anything not in force or existing at the time when the repeal takes effect." It further proves that unless the new law expressly saves pending matters on rights created under the old law, those rights and proceedings die with the repealed law. Clear? So, if a person is being prosecuted under a repealed law, and the new law does not clearly say that the old cases shall continue, then the court loses jurisdiction to continue with the trial. That's exactly what Mazi Nnamdi Kanu is talking about: jurisdiction, striking out the case, and there is no law that is providing, that is backing the prosecution. So I want to make you to understand that Mazi Nnamdi Kanu is not just making noise; he is quoting verbatim points that the court know, and that is why they were silent when he raised that point. Let's go on. What is the repealed law? The repealed law was the Terrorism Prevention Amendment Act 2013. This was an amendment to the original Terrorism Prevention Act 2011, and it won. 11. This law did the following. It defined terrorism as an act of terrorism in Nigeria. It also empowered the Attorney General of the Federation to approve terrorism charges. Also, it granted the DSS and other agencies powers to arrest, detain, and investigate suspects. It established procedures for freezing assets, blocking accounts, and prosecuting terror-related offenses. It was under this act that the federal government of Nigeria charged Nnamdi Kanu alleging terrorism-related offenses such as belonging to an unlawful group, treasonable statements, and operating a radio station allegedly promoting separatism. This 2013 law was the foundation. Listen very carefully. This law was the foundation of this entire trial. Clear? Now, what is the new law? Let us juxtapose it with the new law. What is the new law? The new law is the Terrorism Prevention and Prohibition Act. Remember, the first one was Terrorism Prevention Amendment Act 2013, which is TPAA. Now, this one is Terrorism Prevention and Prohibition Act 2022, TPPA. Now, in 2022, Nigeria's National Assembly repealed both the 2011 and 2013 acts and enacted this new law, which is the TPAA 2022. So you heard it. It repealed that law of 2013 and replaced it with a new one of 2022. Now, Section 62 of the 2022 Act states clearly that the Terrorism Prevention Act 2011 and the Terrorism Prevention Act Amendment 2013 are hereby repealed. Do you get that? Are hereby repealed. That means they no longer exist in law. What changed in the 2022 Act? What changed? What is in this Act that is different from what was in the former one? Let's go on. The new Act reorganized the entire terrorism framework. It created a National Counter-Terrorism Center. It expanded definitions of terrorism financing. Do you understand? It changed prosecutorial procedures. It transferred key powers from the Attorney General to the Office of the National Security Advisor. It set up new penalties, processes, and jurisdictional rules. Crucially, the 2022 Act did not include a saving clause. Now, listen here, because I want you to understand this saving clause. That is where the whole catch is. Meaning that it did not say that ongoing cases under the old law would continue as if the old law still existed. Follow me. Take it easy. Follow me. That omission is what Nnamdi Kanu's argument stands upon. Let's go on. Now, what is the legal effect? What happens when the law is repealed without a saving clause? Listen, let's go. The rule of law is simple. If an act is repealed without saving provisions of that act, then any prosecution, judgment, or proceeding depending on that act dies automatically. The courts have consistently upheld this. For instance, in Waifo versus Attorney General of Bendel State, 1982, 7 SC 124, the Supreme Court held that when a law is repealed, it is as if it had never existed, unless the repealing law preserves rights, liabilities, or proceedings. So, if the new Terrorism Act of 2022 does not save old cases, then the trial of Nnamdi Kanu, which was instituted under the repealed 2013 Act, is legally null and void. So you see the legal loophole, the vacuum that Nnamdi Kanu is cashing in, is targeting. It is clear. There is no law. Now listen again. How does this vindicate Nnamdi Kanu? Now let's connect it directly to this claim. 1. His trial rests on a repealed law. The federal government charges were filed under Terrorism Prevention Act 2013. That act no longer exists since Section 62 of the 2022 Act expressly repealed it. Section 62 of the 2022 Act expressly repealed it. 2. No saving clause means no legal foundation. The 2022 Act did not state that old prosecutions would continue under the repealed law. Therefore, the prosecution cannot rely on a law that has been wiped out from the legal system. Number 3. Also, jurisdiction collapses when the enabling law disappears. As laid down in Madukolu versus Nkemdelem 1962, a court is competent only when the case is before it under a valid subsisting law. If the enabling statute has been repealed, the court no longer has jurisdiction to continue. That is why you hear Kanu say, Omotosho does not have jurisdiction to hear the case. Now also, the timing does not save the prosecution. Even if the alleged acts were said to have happened before 2022 law came into force, the moment the old law was repealed without saving the ongoing case, that case automatically lost its legal oxygen. A prosecution cannot survive when its legal backbone has been removed. Now, the conclusion. Why his claim is legally sound? Why is this claim legally sound? Nnamdi Kanu's position is firmly grounded in law and logic. The 2013 Terrorism Act is repealed. 2022 Terrorism Act did not save the ongoing prosecutions, which they were supposed to do. Now, under Nigerian legal principles, a repealed law cannot confer jurisdiction. Therefore, any trial or charge still relying on the repealed law is null, void, and unconstitutional. Hence, Nnamdi Kanu is right to say that the law cannot legally try him because the statute forming the basis of the charges no longer exists. His argument is not technical escapism. It is a legitimate constitutional question of validity and jurisdiction, which strikes at the very heart of the rule of law. Now, what is saving clause? Because you need to know that was what could have helped that 2013 repealed law to also be valid in the amendment, rather in the new law that was made. That is supposed to have a saving clause. That is how it is done everywhere in the world. If you want to repeal a law and replace the law with another one, you must save the contents of that law, stating it under that new law. Let me show you. Let's go on. What is a saving clause? A saving clause, sometimes called a saving provision, is a special section added to a new law to protect, and preserve certain rights, actions, or cases that existed under the old repealed law. In simple terms, it is a legal bridge that allows things done under the old law to continue to be valid even after the old law has been repealed. It saves past actions, prosecutions, contracts, or obligations from being destroyed when a new law replaces the old one. Simple and that. Now, this is the saving clause and how it should sound like. Listen to how a saving clause should sound like. In quote, notwithstanding the repeal of the TPAA Act 2013, any proceedings, charges, or rights accrued under that act shall continue as if the act was still in force. End of quote. With this saving clause I just read for you alone, that 2013 act would have still held its jurisdiction, would have still been valid under 2022 act. But unfortunately, it is the House of Assembly or Senate who, Nigerian lawmakers and their emptiness, they of course, by stroke of fate, omitted that saving clause, making any other case before 2022 illegal. Nnamdi Kanu holding his base on this saving clause, on this new law that did not save the old one, did not save precedents and precedents of the old one, leaving the law open and exposed for Nnamdi Kanu to take advantage of, and that is exactly what he has done. That is exactly what he has done. It's a legal loophole. That is why it's very important when they say a lawyer can save your life and a lawyer can send you to prison, because the brain is the law, not just the book itself. So Nnamdi Kanu is the brain of law. He has spotted a loophole that even his lawyers and sons in the past could not explore. There are a lot of loopholes in this case. The human rights section, the political section, they should have explored, and I've said it many times, and they should have worked out, staged a workout of this case. Ever since, leaving the case to a political case, but they refused to do it. It was Nnamdi Kanu that later did it, and has finally turned the case to a political case. What the lawyers should have done since, but no. All they want is the appearance fee at the expense of the case. Because all you want to do as a lawyer is to win a case, not to make money. To win a case, the more cases you win, the more cases you will get. It doesn't matter what they pay you. Nobody knows what they pay you. But by the time you keep on putting your eye on money, you lose cases. Nnamdi Kanu's case was a clear case that this lawyer should have explored lots of these things. They should have done their background check, loopholes, read books, read the Constitution, gone through Terrorism Act up and down, look at the charges, sleep, wake up. I bet those lawyers, most of those sons, did not read hard enough. I bet those lawyers, mostly the SANS, did not read deep, did not study hard for this case. They did not do their diligence. Nnamdi Kanu has shown them how to do it. He has proved that this case should not have even got to this level it is if the right things had been done. Omotosho, you have heard it clearly. The old law was not saved. There was no saving clause included in this law. So whatever it was in the old law is gone. If you want to do anything about it, you go to the assembly. But for today, there is no law that, backs Nnamdi Kanu's prosecution. And as it stands now, Nnamdi Kanu is standing an illegal trial, a trial that should be struck off, and Nnamdi Kanu should be set free. Because the court doesn't even have jurisdiction to hear the case in the first place. There is no case against Nnamdi Kanu. Nnamdi Kanu should be free to go home, to his family, to his friends, to his loved ones, to us. This case should end, and end now. Simple. Simple. That is exactly what all this was about. And that shows you that Nnamdi Kanu was not just blabbing, he was actually saying things, reasoning that are far beyond many people's imagination. How could they imagine when they don't read? Does Omotosho read? Does Arumolo, whatever it is, does he read? That one self is even worse. Study! Study to show yourself approved. They will not. All they want to do is collect money, prosecute. Is he a thief? Arrest him. That's Nigeria. Arrest people, put them in prison. You don't even know how to charge people. Their writing is even poor. Their letterhead is even poor. I don't know. I think I read some for you the other day on when they arrested Nnamdi Kanu's lawyers, and charged them to Kuje. They couldn't even spell. They couldn't even spell a headline. I don't understand. What is difficult? Come down and do something. They can't do anything. Illiterates in the civil service of Nigeria. Illiterates. Stop. Conk. You want to try a PhD level, professor level freedom fighter? You go sweat. Illiterates want to charge a PhD level freedom fighter. Oh yeah, now let's go on.
Nnamdi Kanu, Chineke nyere gị mmeri ijiri gaa ije Biafra ma na-eke ma n'orie onye bi imegbu gị Chineke adịghị kwesịrị mmegbu gị. Ọ ga-adịkwa nne gị mma na ezinụlọ gị ma ụmụ gị ma ikwu gị ma ibe gị ma anyị na ndị kụwa ọfọ. Ọ ga-adịrị unu mma gaa lụọ n'obodo. Awụsa gawara onwe anyị agawara onwe anyị. Ogologo ndụ gị na ahụ isi ike. Abego nkịtị nwunye na ọha gwa adịgo okwu. Inyere m right merie inyeghị m ka ị lọrọ ije. Abeele m akwa akụrụ gị. Ga n'udo lọ. Ị ga-emeri. Amen. Amen. Ịlọla. Amen. Ọ dịrị gị mma. Amen. Ma na-eke. Amen. Ma n'orie. Amen. Abego nkịtị gwa adịgị. Ma n'afọ. Otu njide gwa gị. Chineke metụ onye na n'otu n'aha Jizọs. Amen. Metụ onye na n'otu n'aha Jizọs. Amen. Ekpere bụ ọgwụ anyị gbara agbọ n'ime Jizọs ihe sekpere bụ ọgwụ anyị gbara agbọ anyị ga-agwọ.
All right. So after watching this, what do you make of it? Drop your comment in the comment section, all right? I'll be here to get you all the informations. Thank you very much, and may God continue to bless you.